that of him having been in the country illegally, so Your Worship, just in case the court might want to believe that the client was not truthful with this honorable court, the further instructions that I got from the client was that at the time of his arrest, he did not have a passport on him. However, on Monday when he produced, a family member brought the passport. According to him, he never appeared before any honorable court because the passport was legal at the time. He was told he can go back home. So if there is a previous conviction, the client is still not aware of that previous conviction.
Why was that not disputed when the investigating officer gave evidence? Because that evidence is undisputed before this court. It was not disputed, not put. The accused denies he has a previous conviction. There's no denial in that regard before this court.
As the court pleases, Your Worship, I would think that the client, because being I will use the word a lay person, he still maintained. However, I did not want to go beyond the instructions that I had in case there is a profile to that effect, which then in that case it would be the legal representative. Also, Your Worship, when I asked the investigating officer if the client had been cooperative, he said the client had been cooperative with investigations, Your Worship. Your Worship, I would humbly request the Honorable Court to take that into consideration when looking at the provisions of Section 60, subsection 4, Your Worship, to say that the client has no intention of misleading or interfering with the investigations at this point. If the word of the investigating officer is to be taken, Your Worship, that they have the murder weapon and they have already sent the swabs to the forensic, my client has no control and therefore would not be able to interfere with the investigation where it is at this stage, Your Worship. Furthermore, Your Worship, the client does not have, or according to my instruction, Your Worship, the client does not know the state witnesses, those that the investigating officer relied on when he said he was told by an informer. At this point, according to my instruction, the state witnesses are unknown to my client. Therefore, also would say that the client would not be in a position to intimidate the state witnesses or to try and change their mind in any form or shape in order to interfere with the investigations, Your Worship. Furthermore, Your Worship, the client was arrested at his place of residence. Also, I understand that the investigating officer has feared that because he was renting, he may be able to move around at free will should he be released out on bail. Your Worship, I would say that that is why the court has the powers to put on strict bail conditions when releasing a person on bail. Therefore, I would humbly request that when the court considers releasing the client on bail, it could consider that the client go to a nearest police station to go report either twice or even 3 times if it will elevate the state's fears as to whether my client would be able to flee the country. And that will also go to the crux, or rather to prove that my client has intention of ever leaving this matter until its finalization, Your Worship. At the first instance, when he is not reporting to a police station, should the court consider that, then the investigating officer would know at the earliest time that the person is not adhering to the conditions. Therefore, the due processes would follow, Your Worship, as we know that there would be processes to either withdraw the bail or in order to put the person back in custody, Your Worship. Your Worship, what I could gather was that the investigating officer was opposing bail on the fact that the client could be a flight risk, and also on the fact that the state has a strong case.
Yes.
Your Worship, at this stage it's a bail court. The guilt or innocence will be proven in the trial court. I would humbly request this honorable court that if we are to look at, if the state has this strong case that they have, we must also look at the fact that the investigations are not yet completed, so at any time anything could go or change that strand the strength of
But
that
isn't
case.
it also correct that you did not challenge the strength of the state's case? The accused exercised his right to remain silent.
Yes, Your Worship. And that still remains to be the instruction to remain silent. I'm simply alerting this honorable court that what the state has placed before this honorable court regarding the strength of its case, Your Worship, they still have to investigate further. And furthermore, the investigating officer said that they are to arrest 3 more people, if I heard it correctly. They still 3 that would be arrested, and there is no guarantee as to when those people would be apprehended and brought before the honorable court.
But
Therefore,
does the fact that they are currently unable to arrest those accused, regardless of their involvement, the court doesn't know their involvement, their alleged involvement in the matter, but does that affect the strength of the state's case against this accused? Or
No.
the case against this accused? Can the state not still proceed against this accused and separate him from the remaining accused if they are unable to trace them?
Your Worship, I'm trying to go somewhere, and I will get there very fast. When I brought that up, I was trying to tell this honorable court that because there is no time frame and the state was not clear as to whether they will indeed exercise the right to separate the trials. Now, if my client is kept in custody pending the arrest of the others, that in itself, Your Worship, would serve as a punishment to my client to be held in custody pending the arrest of those. It does not change the strength of the case, Your Worship. And in as much as the state at this point, because the investigations are not yet completed, they cannot tell this honorable court for certainty as to whether they would be in a position to proceed without the further arrest that is still to be made.
But
Therefore,
if there is a delay in the investigations, does the defense then not have the provision of section 3428 to their availability to say, but look, the accused has now either been in custody or not in custody, but you've taken too long with your investigations, and as such, we are applying for the matter to be struck off the roll since there's an undue delay that's prejudicing this accused. So is that not something that is more relevant regarding the future of this matter and not really relevant regarding the aspect currently, since we do not know when they might be apprehended or when the investigations might be finalized? But if they do not do so timeously, there is that relief that is available in that regard.
as the court places indebted to the court's wisdom, Your Worship. And also to take it from there, Your Worship, I would say that the state, if they were to release my client, they would still have other reliefs as well. The court has already mentioned section 342A. They would have the relief to bring the accused, either use a J50 warrant of arrest to secure his presence, should he not be before this honorable court. So if the court were to grant bail, Your Worship, and the client dishonors the honorable court, the state still has reliefs to entertain, in as much as the defense would have 342A, Your Worship. Therefore, that in its own would say that the client ought not to be kept in custody simply because he comes from Lesotho. He does have a valid passport. I'm trying to tell this honorable court that the fact that the investigating officer said that if the client was to surrender the passport, he would use other means. There is no evidence before this honorable court that he would use other means, or there is no evidence before this honorable court from either the state or the defense that the client ever has had a warrant of arrest issued against him.
But
now,
is it not evident by other means to say that he's got a previous conviction showing previously that he entered into the country illegally? As such, he knows how to enter or where to enter, or since he's done it in the past, he could do it again.
as the court pleases, Your Worship, going back to my instruction, as I was telling this honorable court that the client had said that he did produce.
The investigating officer is that he has a previous conviction and that it was not challenged. The court can only take into account evidence, not an address from the bar to say my instruction now is he does not have a previous conviction. Because the evidence before this court that was not disputed is that he does have a previous conviction. And the court can therefore not ignore that previous conviction. We have to deal with it since it's undisputed.
As the court pleases, Your Worship, if we are to deal with it without addressing from the bar, I would say that if indeed the client does have a previous conviction of being illegal in the country, and now before this honorable court, the client has a valid passport, it would go to show that the client had learned his lesson and did what was necessary to be as a valid passport.
Anything further?
Nothing further, Your Worship.
Thank you. Addressed by the state.
As I could please, Your Worship, Your Worship, to cut to the chase, what is in dispute here, Your Worship, is a Schedule 5 bail application. The accused must show proof that it's in the interest of justice. Your Worship, yes, I hear we didn't lead evidence in the regard in respect of the other accused, but Your Worship, just to alleviate the fears of the defence that the trial might be dragged out because the other accused are not found, it's the same case that accused number 1 murdered the lady Miss Sibongile. Your Worship, afterwards the other suspect that we are looking for is the people to help to dispose of the body. They were not involved in the murder. So it will not delay our case. We are cutting to the chase in respect of accused number 1. We, of the opinion, we have a very strong case that the accused number 1 murdered the accused number, the deceased, and he disposed of the body. With that, he needed assistance to dispose of the body. So if we do not get the other accused, it would not affect our case in any way, the strength of our case. Your Worship, the state has a very strong case, Your Worship. There was pointing out the accused produced the murder weapon, Your Worship. At this stage, it was sent to the forensic laboratory, Your Worship, for comparison, just to verify. Although accused said that it was a murder weapon, we obviously have to verify it with the blood that was found in it. Your Worship, if I look at the circumstances that the accused raised when he should get bail, the one was that he had to maintain his wife and child. Your Worship, in that respect, I refer you to Bail a Practitioner's Guide, Your Worship. For ease of reference, I made a copy of page 157 that I would like to quote. It goes to the rights of that child. Specifically, that was the first point that was raised. He had to maintain his wife and his child. In page 157, last paragraph, in the case of S versus M, 2007 brackets 2, SAC R359CC, Your Worship, it was dealt with the interest of children whose mother had been convicted of fraud and sentenced to imprisonment. Although the present case deals with the incarceration of the mother of a child pending trial, the interest of the child, it would appear, required consideration in the same way as if the mother has been convicted and imprisoned and was being considered as an appropriate sentence. After discussing Section 28(2) of the Constitution, Judge Sachs held that accordingly, the fact that the best interests of the child are paramount does not mean that they are absolute. Like all rights in the Bill of Rights, their operation has to take account of their relationship to other rights, which might require that their ambit be limited. Your Worship, in this matter, the accused is not the primary caregiver. The 1-year-old child is in the care of the mother of that child. Your Worship, the investigating officer also testified that that mother of the child, after this case came to light, she returned home, and home was referred to as Lesotho. So accused So in any event, with the complainant, with the accused's wife being out of the country, Your Worship, I'm of the opinion that not too much weight can be on the fact that he has to maintain his wife and child. It appears that she already returned to her family. Then, Your Worship, his other was that he has to pay rent, and he had to pay his sister for college. Your Worship, whether that may be the case, Your Worship, he's not the primary caregiver here of the sister or the child. So, Your Worship, I'm of the opinion that his circumstances that he raised doesn't carry enough weight and does not outweigh that. Your Worship, we can also see the community. Your Worship, there's numerous people here in support of the case. Your Worship, the community are opposed to the bail. The ANC Women's League, the EFF, and numerous community forums has been here to inquire and raise the issue that they wanted to state to oppose bail. Your Worship, even the investigating officer said that he's not sure that the community would like to get hold of the accused number 1 so his life is not safe. Your Worship, in short, I'm of the opinion that the defence did not shift the burden of proof to prove that it would be in the interest of justice for the accused to be released, and the state's going to request that bail be denied.
Any response?
As the conclusions, Your Worship, with regards to the community or the forums that the state is referring to, Your Worship, there is no evidence before this honorable court that they would do anything to harm the client. The accused that is still applying for bail. Already one is out on bail, and there is no outrage that the state wants this honorable court to believe that the community is that enraged, Your Worship. Your Worship, I would humbly request that the interest of the community not be upheld at so much esteem in opposition to the rights of the client, Your Worship. It's still a bail, and there is no guilt that has been proven of my client. Therefore, I would still humbly request this honorable court to consider releasing the client out on bail on the amount that was in the affidavit. As the court pleases.
Thank you. Judgment in this matter. This is a Schedule 5 bail application. The offences charged resolved with under Schedule 5 the Criminal Procedure Act, Act 51 of 1977. Therefore, the duty lies upon the shoulders of the accused, being the applicant hearing, to prove on a balance of probabilities that the interest of justice permits his release, as stated in Section 60, subsection 11b of Act 51 of 1977. Interest of justice. The concept of interest of justice is not defined in the subsection. However, in the matter of S versus Lamini, S versus Glagla and others, S versus Joubert and S versus Skitakat, 1999, in brackets 2 SACR 51cc, the concept of interest of society was defined as follows. The interest of society, in the sense in which the interest of society concept is used in subsection 4, it is read first, and the interest of justice bears the same narrow meaning, akin to the interest of society, or the interest of justice minus the interest of the accused. The interpretation of the whole section falls neatly into place. The concept of interest of justice is thus a combination of a number of factors which result under 5 very specific subheadings. The pivotal question here is whether specifically likelihoods would present itself if the accused is released on bail, namely the endangerment of the public safety or a specific person or commission of a Schedule 1 offence by the accused, that the accused will attempt to evade his trial or attempt to do so, the accused will influence or intimidate witnesses or conceal or destroy vital evidence or attempt to do so, that such release will jeopardize the objectives of proper functioning of the criminal justice system or bail system, that such release will cause a disturbance to the public order or undermine public peace or security. This is with specific reference to Section 60, subsection 4A to E. Each of these subheadings in turn also contains a number of aspects to consider in deciding whether such likelihoods is present or not. Further, this is with reference to Section 60, subsection 5 to 9. In addition, it's also important to note that the interests of justice do not permit the release of the accused person on bail when any or more of the above-mentioned likelihoods have been established, as set out in Section 60, subsection 4, also confirmed the matter of Mhlongo and others, versus S 2011, ZAF SHC 14 at paragraph 21, judgment by the Free State High Court. When a finding is made that the interests of justice do not permit the release of an accused person on bail, the court adjudicating the bail application shall order his detention of such an accused person until the finalization of the matter. It is important to note that the right of an accused person to his personal freedom is not an absolute right which overrides all. His right to personal freedom has to be weighed carefully against imperative duty of the state to protect innocence from crime, also confirmed in the matter of Mhlongo as stated supra. For purpose of this judgment, I will only deal with the likelihoods as well as determining the factors which I deem problematic in respect of the matter at hand. Therefore, the likelihoods which do not raise any concern with me will not be dealt with. In deciding the question whether the release of the accused person on bail will cause the endangerment of the public safety or the safety of specific persons, or that he will commit the Schedule 1 offence, as stated in Section 60, subsection 5, makes reference to a variety of factors which need to be considered. Firstly, prevalence of the offence charged. The offence of which the accused has been charged is a very prevalent offence in this court's area of jurisdiction. He faces a very serious charge, and this court has numerous matters of the same nature in this court on a daily basis. Further factor the court needs to consider is previous convictions or pending matters. The accused does not have any pending matters in this court or any other court. However, the accused does have one previous conviction, the contravention of section 49, subsection 1 of the Immigration Act, Act 13 of 2000, in terms where he was convicted of being illegal in the Republic of South Africa. In this regard, although in argument by the defence, it is stated that the accused does not have a previous conviction, when the investigating officer specifically testified in this regard, his evidence regarding the previous conviction was undisputed and therefore accepted by this court. I deem past conduct of an accused person as the best indicator of future conduct. In this instance, my viewpoint is supported by the following cases. S versus Muhammad, 1999, in brackets 2 SACR 7, in bracket C. Mazibuko versus S, 2022, ZAF SHC 15. Also Mazibuko 2010, in brackets 1 SACR 433 KZP. And Nseki versus S 2016, ZAF SHC 156. In this regard, the court is concerned specifically since the accused is a foreigner, although he is currently legally in the country. Previously he had a conviction for entering into the country illegally, and as such it is well known how to enter into the country legally or to leave the country without using the legal border posts. Further factor to consider is the ties the applicant have to the districts where the matter will be heard. In deciding the question whether the release of the accused person on bail will result in them evading their trial, Section 60, subsection 6 provides a number of factors which should be considered. These factors mainly boil down to the emotional, family, community, as well as occupational ties that he has in this court's area of jurisdiction. Firstly, when we look at the family ties, although there is evidence the accused is married and he has one child, the evidence before this court is that after his arrest, his wife vacated the address where they resided and went back to Lesotho. He therefore currently does not have any family ties within this court's area of jurisdiction. Occupational ties, he testified that, or the evidence that was led is that he is a hawker selling goods in the CBD. It is therefore also concerning that he does not have a fixed employment. However, he can pack up his business and relocate to any place at any time without any prior notice. Furthermore, further aspect to consider is assets within the court's jurisdiction. There is no evidence before this court that the accused has any assets within this court's area of jurisdiction. The further factor is the availability of travel documents. The accused does indeed have a passport, although it has been confiscated by the investigating officer, and as such this further would prompt the accused possibility going back to his previous conduct of entering and leaving the country illegally. Further factor to consider is the nature and the gravity of charges leveled against the applicant. The applicant is charged with a very serious offence. The charge is so serious that the trial on the merits might even take place in the Free State High Court. There is also a minimum sentence that is applicable. Upon conviction, long-term imprisonment is staring the accused in the face. When a person is arrested on a charge on which he faces the process of punishment of long-term imprisonment, the risk of abscondment is ever present. This was confirmed in the matter of S versus Mslangu, as well as the matter of S versus Muhammad, 1999, in brackets 2, SACR 7C at paragraph 37. This is even more so when an offence charge falls within the ambit of section 51 of the Criminal Law Amendment Act, Act 105 of 1977, in terms whereof the accused faces life imprisonment. The strength of the state's case will therefore play a pivotal role in this matter as well. When we look at the strength of the state's case, the accused exercised his right to remain silent, which is his right. However, the investigating officer in regard to the strength of the state's case testified as follows. Upon arresting the accused and inquiring regarding the whereabouts of the victim, he confessed to them that he killed the complainant. He then went to show them where he put the body of the complainant. He then took them back to the house and he then pointed out where he hid the murder weapon. On identifying the murder weapon being a hammer, there were 2 hammers found, blood on the hammer, and he then pointed out exactly which one of these he then used. As such, it is very clear that the state indeed has a very strong case against the accused. As such, the accused in this matter has an additional hurdle to overcome. Although it is argued that the state might not have a very strong case, it is indeed so that they do have a very strong case against the accused, and as such the court duly needs to consider this, and if this emanates the accused being a flight risk. This was also confirmed in the matter of S versus Matebula 2010 1 SACR 55 SCA paragraph 12 to 13, as well as S versus Van Wyk 2005 1 SACR 41 SCA. The strength of the state's case against the accused is but one of the factors to be used that will show his likelihood that he might evade his trial. A lengthy sentence can serve also as an inducement to evade trial, as confirmed the matter of Panyotu versus S 2015 ZAE CGHC 73 and S versus Mpumalanga 2007 brackets 2 SFCR 133 at paragraph 135H. It is however not the duty for the court at this point to decide upon the accused's fate and upon his guilt. The court only needs to assess the strength of the state's case if the state indeed has a prima facie case. Taking all of this into account, as well as the undisputed evidence before this court, the court does find that the state indeed has a prima facie case against the accused. Furthermore, regarding the factor whether or not the accused will disturb the public order, it is so that there has been a lot of media as well as members of the community that have been present at court, and it is understandable that the family are grieving at this point in time and angry for what has happened, and that the evidence of the investigating officer sent a further shock to the community since the accused has admitted to the crime that he's committed before this court. In this regard, there might be public disorder if the accused is released on bail. When the court takes all of these factors into account, the court is of the opinion that the accused, if released on bail, there will be a possibility that he might commit a further Schedule 1 offence. There's further the likelihood that he might evade his trial, and there might also be public disorder. In this regard, the factors as set out in section 64A to E are indeed present in this case. The court therefore needs to decide if there is any conditions the court can set if the accused is to be released on bail that he will alleviate these fears of the court. Taking all of the evidence in this matter into account, the court cannot see any bail conditions that will alleviate this fear of the court. Accordingly, it is not in the interest of justice that the accused be released on bail, and his bail is therefore denied.
Jwale le kota le tlhalositse mona he hore le tlo bua ka ntlha tse leng hore di kgetha tema kopong ena ya hao ya beili. Le kota le buile jwalo ha le tlhakowa sethatong la bua le kotsa nyewe tse tharo e neng le ya thamene dubeng le skite ka. Le kota le tlhalositse jwalo he hore ha e ba ile hore o na le kgonahalo ya hore ha mokusi wa ka lokolwa ka beili o ka tlisa a hona le kgonahalo ya hore a ka balea tlhella ka pela le kota se no le kota le ntse le ka nna la hanela ka beili. Hai ba ile hore ha o ka lokolwa ka beili o na le kgonahalo ya hore o ka etsa tlolo e nngwe ya fe ya molao le kota le ka o hanela ka beili. Ya bobedi le kota e le tshiteile moduma yona hape ke ya hore e bangile ho ka lokolwa ka beili ana o ka sitisa tsamaiso ya tsa toka kapa jwang kota le re bona seno e le kgonahalo e teng hore o ka na wa sitisa tsa toka phethahatso ya toka hobane kgonahalo ke ya hore o ka nna o iphadi menyane wa kutela na ya eno ya Lesotho hobane mona South Africa kapa setrekeng sena sa lekota lena la dinyewe ha ona maqhama ho hang ha ona letho le o tshwarella mona o ka nna jwalo ka ha o le morekisi wa mebileng o tse o ka nna wa phutha se le sa hao wa nyenyelepa wa petse ya wana ya namenya eno ya Lesotho mme he lekgotla le hlalositse hape hore ka mora hore kolo ena molao e tle e hlahelle phatlalatsa ke me eleng hore mofumahadi wa hao le lekgabunyane la hao ba la ba phuthaphutha se leng sa bona ba phutlela ha bo lapeng Lesotho jwale ha o sana mangwe mona South Africa e leng hore o ka re motho ya ne ke ena ntshwarellang hore ke le South Africa le ya boraro hape lekgotla le shebileng ke ya hore tlolo ena ya molao e o tjamelaneng le yona ke tlolo ya molao e leng hore e se e ratile ho ja setsi haholo setereke sa lekgotla lena la dinyewe le Afrika Borwa ka bophara e o na le bokotsi bo e leng hore tsatsi le tjhabang le le dikelang lekgotla lena la dinyewe le tlameha le mekamekane le ditlolo tsa molao tse tshwanang le tsena e bang o ka funwanwa o le molao lekgotla le re o le ba o shebane jwalo le nako e telele hampe tjhankaneng se leng hore seno se ka etsa hore utlwe hore o kekebe wa emela o batla ho ipha dimenyana lekgotla le re hape le shebile taba ya hore ditlolo tsa hao tsa molao tsa kgale mme kileng wa fumanwa le molato ke lekgotla la dinyewe Afrika Borwa mona ke tlolo ya molao ya hore o lawa kena ka ho Afrika Borwa e o roba molao wa le wa mashome a manana le motso e robong le molawana wa pele ka masakaneng mo e leng hore o la robile molao o laolang ho tswa le o kena ka ho Afrika Borwa jwale le fokisile la bua hore a nka nna a mpha yona passport ya hae ka e tshwara seno ha se bolele hore o thuswa a kekebe a baleya hobane o ntse a kile a kena o tseba metjha ya ho tswa le ho kena ka ho Afrika Borwa e le ka tsela le mokgwa ya ho tshela thata ya mahuo jwale lekgotla le hlalositse mono le bile le bolela taba ya hore e bang o ka lokollwa a na ho setjhaba kapa phakathi jwalo ka re tseba ba tla ba le bothata na ba o ka lokollwa ka peini na o tloha sethathong sa le ntse re bona ho na le matulwana a ileng hore a e se matulwana mekgana e leng hore ntse e tla e tlo tshehetsa kapa e mamela nyewe e bontsha hore na le thasello nyeweng ena jwale seno se bontsha fela hore ho na le bothata setjhaba se na le bothata ba ho ka lokollwa ka bei lekgotla le nkile qeto ya hore motho e leng hore ha lokela hore ya ka fumantshwa beili wa tswa o sa kwalletswe mona.
Mr. Court, please, Your Worship, the state requests that the matter be postponed for further investigation until the 28th of March. Your Worship, the post-mortem and chain evidence is still outstanding. The DNA reports, as well as a witness statements and LCRC report in respect of the evidence that was gathered.
Date suitable?
The date is suitable, Your Worship, as the court pleases.